Thank you for joining us today, Wednesday, March 25th, for NCBA's 2021 Back to Basics webinar entitled Pretrial Practice. I'm Nathan Wilner, NCBA's Government Affairs Officer, and I'd like to welcome you to today's webinar. Now for a few housekeeping items. This information is for the use of webinar attendees only. Any distribution, reproduction, copying, or sale of this material or contents hereof without consent is expressly prohibited. This information is not to be construed as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure that this information is up to date as of the date of publication. It is not intended to be a full and exhaustive explanation of the law in any area. This information is not intended as legal advice and may not be used as legal advice. It should not be used to replace the advice of your own legal counsel. The opinions expressed are the views of the authors alone and should not be attributed to any other individual or entity. Okay, now I'd like to introduce our renowned speaker, Mr. Mitch Williamson. So Mitch Williamson, a 1989 graduate of New York Law School, is of counsel to Barron Newburger PC and is in charge of the firm's New Jersey office representing law firms, debt buyers, collection agencies, and other businesses in litigation and government investigations. He is RMAI certified and has an AV preeminent rating from Martindale-Hubbell. Mr. Williamson is also the ACA MAP chair for New Jersey. Prior to joining BNN, he was in-house defense counsel to Pressler & Pressler for 13 years, where he also handled collection cases, including trials in New Jersey and New York. He is admitted in both the state and federal districts of New Jersey and the state and all four federal district courts of New York and the second and third circuit courts of appeals. Mr. Williamson is a frequent speaker and regular contributor to national blogs on issues affecting creditors' rights. We appreciate you for taking the time to join NCBA's Back to Basics webinar. And I believe with that, we are ready to get started. So Mitch, the floor is all yours.
I see you used an old picture. That's when I was shooting to go to the Florida office. But anyway, okay, pretrial practice. As you can see, what's the first things you need to understand? The who, what, when, and where. Let's go to the next slide. Who's your client and what kind of debt you're pursuing? This is crucial right up front. Is it purchase debt? Is it medical debt? Is it medical debt from a hospital? Is it medical debt from a local doctor or dentist? Is it a small business in your area? That's going to dictate what kind of documents and exhibits you produce throughout the case. In all likelihood, if you're dealing with a small business, a local business, you're going to have more contact with your client, and there may be questions about the likelihood of recovery, what the cost may be, and how long things will take. That's something that's going to be specific to where you're located, what courts you're in. We will talk a little bit, but the different courts often have different timelines for what goes on. By way of example, in the middle court in New Jersey, special civil part, which is where most collection cases are, there's a 90-day, they like to shoot for a 90-day window from the start of the litigation to the end. In small claims, it's a little shorter. In law division, which is an upper division, it could be considerably longer. It could actually be years. That goes the same with New York, when you're in the city courts or in the county courts. Likelihood of recovery, this is something that oftentimes you'll check. Credit reports, is the debtor have 6 other cases in collection, or are you the only one? That'll make a real difference on what the likelihood is of recovery, because if they got multiple cases, they're spread out, and it's not realistic that you're going to be able to collect. Also, you want to see if you've got other accounts with that debtor in your office, which oftentimes happens. And is this the first case that came in, or is this the third case that came in? Because that too can affect your recovery, since those first cases will need to be paid first before they get to yours. And you need to advise your client that there's others in line in front of them, and are likely to collecting. No, next slide.
Mitch, you mentioned a good point, and I think that information is also really critical, because it also will affect your ability to settle the case. So if you know there are other cases ahead of you, you might want to advise your client that to take a different type of settlement on a file if you don't have that information. So I think that's critical when practicing in this space.
And also, you've got an ethical responsibility to your other clients to advise them that you now have another one, and maybe you're talking about settling case number 3. I think you have an ethical obligation to advise clients on case number 1 and case number 2 that might happen, and discuss that. Because if you prefer one client over another, that can lead to problems with your clients. So you want to be upfront. The more you tell your clients what you're doing, keep them in the loop, the better off you'll be. And they may say, fine, that's no problem. Our debt is such that we're willing to wait. Go ahead. Or they may have a problem with that and say, we want our money. We don't want you to settle with somebody else before we get ours. We were here first. So that's important on that score as well. Next, going to the next. Okay, so does the file have adequate documentation, or can you get it on request? Again, that depends on the kind of case it is. By way of example, if it's a medical debt, do you have in hand the bills that went out, the invoices, the explanation of benefits? And if you don't, do you know what the time frame is for when you can get it? If you're doing purchase debt, do you know how long it will take if you have to make a request to your client to get statements or the terms and conditions if you don't have them? That too is important, because with some clients, I know in the past, some clients you can get it within a week. Other clients, it could be more than a month. And that may impact on how you deal with the debtor or the debtor's attorney, knowing how long it's going to take to get that information. You may need to put things off. You need to know if especially when it's a local, is your client available to review and sign the creditor's affidavit? That's crucial when you've got somebody local, or you've got a direct, even if it's a bank or a credit card, you've got a direct. There's no intermediate, it's not purchased. I've had cases in the past when I was doing collection work where clients which were direct, but they weren't available to sign off on an affidavit of some kind. Courts don't understand that, and they say, well, you directly represent this client. Why can't you get them? If they're not willing to cooperate to get their money, then why should I award them any money? And that's important to know that, and to deal with that, and to explain that to a client if they're giving you a hard time, and explain to them why it's important that they be more available, particularly when it's a local client, say a doctor, a dentist, an accountant, a small business. Is your client available to answer questions, respond to settlement and payment offers? That's another good. Can you get to the client when you need to? One of the things that,
Mitch, one of the things that you mentioned that I think is so critical is, especially if you have a larger client that has its own internal bureaucracy, is to know their process. And for instance, in different states, the court systems work differently. Trial dates come up quicker in different courts, even within the same state. So if you have a client that says, well, I need 30 days or 60 days, and there's a process and a certain email that you have to send things to get these things signed, if it's not working with the system that you're in, you need to advise the client, exactly what the timeline is, how court cases are set, and what's the obligation of the court. Because again, you'll find yourself in the same situation repeatedly if you don't do that.
Right. I was going to say that I had clients they required at least a 30 to a 60-day advance notice. So that's something that you need to know if that's going to be the case with your client. You need to get out a notice to them immediately, that even maybe in some cases before you get a trial notice, but when you can gauge trials, it's likely to come up for trial, and notify them that it's likely to come up this week or that the following week. Will you please let me know what's the availability? Also, for instance, if you've got a local doctor, dentist, etc., They may be available on certain days and not others. Say you have a doctor who goes to the hospital one day a week. You want to know what that day is, so that's a day that he's not available. And again, that's something that the sooner you know that, if that's the case and you're going to need that professional, you can notify the court that my client had, due to other responsibilities, my client can't appear on Wednesdays. Can we do a trial on a Thursday or a Friday? Something of that nature. But you need to know that in advance as soon as possible to be able to take those steps and to communicate with both your adversary and the court. Let's go to the next slide. All right. Who's your client? How do you get your client data? And this is kind of important. And what data are they transferring? Let's start with how is the information transferred? In most cases, when you're dealing with, for instance, purchase debt, they're sending it via a spreadsheet electronically from their system to your system, and it's usually, in many cases, it's automatically input into your system. Other cases, in other situations, it's manually inputted. But do you know that you don't need to know the details, but you need to have some sense that this is how they do it. They send us they send us, for instance, they send us an Excel spreadsheet every once a week. We can't change it. It's unchangeable. It's locked. All we can do is take that information and put it into our file. And that's important at some later date when there's issues about address, social security number, other personal information, to determine, well, this is what we got from our client, as opposed to this is what we found out when we investigated at a later date. And that does come up. So you want to know if that information is something you can play with when you get it. You also know what they're conveying to you. Are they sending you everything? Particularly when you're talking about credit cards and retail accounts. Are they sending you their notes? Are they sending you any disputes that have been raised? That comes up oftentimes when there's been a dispute with the creditor and you don't know anything about it. It's never good. That's never good, but it'll happen a lot. So you'll get the debtor will contact you or their attorney. Well, we disputed this with the creditor. It never got resolved. Well, you need to know that, and you need to maybe deal with that and go back to your client and say, look, we got to resolve this because the court's going to ask some questions and we're not going to have answers. Have fraud allegations been filed with the creditor? Has there been balance adjustments since it was sent out? These are all, to get a general sense of how the particular clients are conveying and what they're conveying. Certainly, for instance, for doctors, are they sending you over their entrance forms, their financial responsibility forms? Are they sending that right at the get-go, or do you need to ask for it? This is another to get a sense, of who you're dealing with and how they do things. Let's go to the next one. Okay, who's your defense? And by the way, if anybody has any questions, please type them in the box and we try to address them. Right party research. That comes up oftentimes when you've got father, sons, there's a junior and a senior. Doesn't happen as often with females, but it certainly happens a lot with males when you're going after the father and you really should be going after the son, or vice versa. Social security numbers. That's a particular problem sometimes. You need to know if you're getting the social security number that came from and this is particularly in purchase debt, if you're getting the social security number that was used to open the account, or for some reason it was skip traced by the debt buyer or somewhere down the line. I had a case one time where the debtor vehemently objected, it's not me, it's not me, it's not me, I'm not your guy. And his name was something like Sam Brown, and he lived in Newark. He went so far as to handwrite the list of 50 Sam Browns that lived within Newark. to show that it wasn't necessarily him. And it turned out eventually I discovered that the client, the debt buyer, had skip traced and got the social security number. And when we did more research and we got statements, we discovered he was right. He wasn't the right guy. But it spent a lot of time and money litigating, first trying to collect, then litigating when there was a Fair Debt Collection Practices Act lawsuit to finally come to that conclusion. And that goes back to, again, in terms of documentation, had we had the statements, we would have been able to check the statements against the social security number or the date of birth or the address. The address in particular. You want to see is the address on the statements the same address as you have on the information you got from the creditor. And if it's not, you want to figure out why. That's a question you need to ask. Maybe it's innocent, maybe the individual moved. Or maybe it is the wrong person you need to check. When it's corporations, businesses, if you don't know where they are, you do research at various states. Corporation, Department of State. Oftentimes you'll serve the registered agent in their state if you don't know their specific address. But that doesn't happen too often. I'm going to assume that most people on this call are doing retail collections, so that's not really a major issue. Let's go to the next slide. And I've been talking about this. How do you determine whether it's the right party you're suing? What we'll have oftentimes with credit cards is that it could be a business card or it could be a personal card. And sometimes it's a business card, but it's in a person's name. And sometimes getting the statement will help you ascertain that. And sometimes it won't. Certainly if it's a corporate card or business card, you want to know about that, because then it's not, the FDCPA is not applicable to a business account. And oftentimes what I've seen is the individual debtor will claim, it's a business card when it's a personal card, and vice versa. And if it's a business card, is there personal liability for that individual? And that's important that you get in discovery, you find out whether you get it from your client in the application. That's going to tell you, did they assume personal responsibility for the account, and then you can go after them as an individual, which is all right. I think that's the next. Okay, going to move on to the next one. Okay, now we come to some of the other issues that need to be reviewed as soon as possible. If the debtor is represented by counsel, well, the only way you could possibly know that right up front is if you've had prior contact with that debtor. And if that's the case, if you've had a prior case with that debtor and they were represented by counsel, then best practices are to contact the counsel in writing and ask, are they going to represent them in a new case? If you haven't, I like to ask them, are you going to accept service for this new case? And put a time frame in. I think it's best is 14 days. If I don't hear from you within 14 days, I will assume you're not representing the party, and I will contact them directly. That way, if there's any problems down the line, you've covered yourself. You've got a written trail of the actions you've taken, and they're in the file, and you notate your file if any questions come up. If there's been a prior no contact request, that's something that again, if this is coming from your client, have they contacted the client and said they don't want any contact? In which case, I wouldn't be calling them. I would send them the initial letter that you're required to send, and then I would file suit if I don't hear from them. Is the defendant a military member? That's the Serviceman's Credit Act. I can't remember the full name, but that's something that your firm should be doing a scrub on. And we're going to talk about that. Bankruptcy, deceased, and those are scrubs. And when I say scrubs, which means that the law firms most use services where they'll upload periodically a list of all the cases, and a company will then scrub it against the national data banks for bankruptcies, for deceased, whether they're in the active service. You need to know how that's done. You don't need to know the details, but you should know if you use what service you're using, how often it's done. Is it once a week, once every 2 weeks, every 3 days? Is it daily? How that's done for each of those categories. It's not bad to know, it wouldn't hurt to know the company that you're using. And is it a checklist in the note set that it's been done? And if it hasn't been done, and it needs to be, is there something in your system which won't allow you to take further action until it's done? Is there some kind of a block within your system? And that's something you want to know. Find out, can I send out a letter without a bankruptcy check, or the system not allow it? Many systems have those kinds of blocks, so you're kind of covered. But that too, you want to know that I could, so that if, let's say you send out a letter by accident on a bankruptcy because it didn't click. If you've got processes and procedures, that there's a flag on this, that it's checked for bankruptcy, you know how often that is. And the way the system normally works is that there's a check, there's some kind of a block on sending out letters on a bankrupt case. You've set up, should it become a problem down the line, what's known as the bona fide error defense. But you have to have it documented, and you have to understand it. It's also, if the issue of meaningful attorney involvement comes up, which we'll talk about a little bit later, but this is also as part of meaningful attorney involvement. Being an attorney, reviewing your file, understanding what happens and how it happens. You don't need to know all, it's okay if somebody else does this, but you need to understand what they're doing, how it's being marked in your file, and be aware and say that you've checked that it's been done. Next, we go to the right balance, the venue, the jurisdiction, and whether it's within the statute of limitations. Those are all extremely important. And how do you know if it's the right balance? Well, you want to get a charge-off statement, or you want to get the bills, the invoices from the client. And you can check, is the balance in that initial letter the same as on the charge-off statement, or on the last invoice the doctor sent, or the hardware store sent out? Is it, if it's a local business, you don't have too much trouble about venue. Or jurisdiction, you're going to be filing it locally, but let's say it's purchase debt. Well, certainly there might be a jurisdictional issue in the terms and conditions, which will make a difference, and that'll affect the statute of limitations. For instance, some credit cards are bound by North Dakota law. Some cards, I think it's Barclays, where it's Delaware law, which is stated in their terms and conditions. You really need to look at the terms and conditions ahead of time to understand, and the statute of limitations, which is a major issue these days, that's going to be dictated by those terms and conditions, and what state laws apply, and what the statute of limitations is. Again, many firms have created a matrix within the system, so the system automatically checks that. And again, you need to know, is that how it works in your firm? Does the system check automatically? Does it have the general terms and conditions for the different underlying creditors that your clients deal with? You represent ABC Debt Buyer, and they normally buy debt from Bank of America, Barclays, and Capital One. So do you have the terms and conditions for those three, and have they been set up in the system so that when a claim comes in, a purchase debt, you see, oh, it was a Barclays account when it was live. So our system's going to pull that the Barclays account, it's a 3-year statute because that's Delaware law. You need to have an understanding of that's what happens, how it works. Again, so you don't make a mistake, so you can catch errors. And also, if the question comes up, that's called being meaningfully involved, or acting as an attorney, as I like to call it. Jurisdiction, as far as venue, well, you need to sue either where the debtor lives or where the contract was consummated. Most times you're going to be suing where the debtor lives, and in most cases, in most states, it's within the county that they live in. That gets a little iffy, and this is a funny story, not so funny. In some jurisdictions, in some areas, it's very tough to know what the proper venue is. I once had a case in the area of Buffalo. I spent 2 hours with another associate trying to figure out which was the right court, making phone calls even to the courts. And we never did figure it out. And I know that that's happened in Pennsylvania. You've got overlapping areas. I know that's happened in New Jersey. So some states will have 1 or 2 towns where there'll be the jurisdiction. It's tough to understand where the people live. And if there are, by this point, most firms will be aware of where those spots are, those hot spots, and you got to pay. And if you get a claim that comes in with that address, with a particular address, hopefully it'll be flagged, and a little more time and effort will be spent to make sure you're in the right place. Because if you're in the wrong place, 9 times out of 10, that ends up being an FDCPA lawsuit. Okay. Nathan, if you have any comments?
Yeah, no, I mean, I think what you mentioned is really critical with jurisdiction and venue. I know in Maryland, there are many jurisdictions and most systems are set up by the consumer's zip code. And you have situations, for instance, Baltimore City and Baltimore County, or there are places in Howard County where there are the same zip codes, but can be in multiple jurisdictions. So to rely on your system completely, even though it's set up, electronically to match jurisdiction by zip code, sometimes if you know that a zip code can be in various jurisdictions, you need to go in either into land records or to some other statewide database that will show exactly where that consumer lives. And again, you don't want to find out the hard way that you filed in the wrong suit, because it's strict liability, and you're going to be sued ultimately if you keep doing that.
And if you do the research, like I said, explain like the time that I spent 2 hours looking at it. Well, we did it after the fact. Had we done that, when it came in and we were alerted to the problem, that would have set up, again, a bona fide error defense, because we had done everything humanly possible to check that. And I guess the thing is that hopefully the system will at least identify, so when you get something, a Howard County or a Buffalo City, that would alert you to, okay, it's a Buffalo City, that one you got to look at. There's some kind of a warning built into the system for those locations which are tricky. All right, now the documents to review before the initial letter. Original account level documentation. That's what the CFPB has been really pressing on that issue. And that's what we have been talking. These are documents you really need, and you needed them long before the CFPB came into effect, because it tells you so much. Statement of account showing the balance of charge of and some account activity. That's going to show you the right number, but it's also, the account activity is going to tell you if you've got the right person sometimes. And if you do, it's going to give you some really good information, particularly when you've got local businesses of a certain type, or you've got charges which don't seem to make sense. That happens sometimes as well. I've seen personal accounts and you've got charges of like $10,000 flat. Then you've got an $11,000 charge. that's got to raise some questions. Is this a personal account or is this being used for business? Because that's not, doesn't sound like a personal charge. The chain of title. We haven't mentioned that before, but that is crucial if the account has been purchased. There is currently going on, there's a ton of lawsuits. I think I counted 22 since January 1st in New York by one particular law firm challenging the chain of title. And every single lawsuit, the claim is the same thing. The debtor doesn't recognize the current creditor. They never had any dealings with the current creditor. And they know nothing about the debt with the current creditor. And the answer to that is, well, here's the chain of title showing that Bank of America sold it to ABC Corp, or Bank of America sold it to ABC Corp, which sold it to XYZ Corp, who is the current creditor. You need that chain of title to explain that. And going on that, there's something else that a lot of the banks are now doing, which is sending a goodbye letter, what I call the goodbye letter, saying this is to advise you that your account has been sold to ABC Corp. And in your initial letter, you're going to want to be able to say your Bank of America card, which has been purchased by ABC Corp, who we represent, and so that the debtor understands how they, what is going on, because no debtor is going to recognize the ABC Corp. They've never done business, that's true. But you want to understand that that's something that's picking up steam lately. I'm not sure why, other than there's the lack of claims they can make, but that's picking up steam with that claim specifically that they don't know who the they don't know who the current creditor is. As I talked about before, the contract or the terms and conditions are important because nothing else for your choice of law and your statute of limitations issues. You need to have those. You also want to see if there's an arbitration clause in those. Once upon a time, I had clients that were using arbitration on collection cases. They stopped that, but that is a possibility. If you've got an arbitration clause in the terms and conditions, you may be able to use that, and depending on where you are, that may be a way to go as opposed to filing a lawsuit. Depending on what that arbitration clause says and what your local rules are. It's something to consider.
Mitch, another thing that why it's so important to have those terms and conditions and have a folder in your system that has, the last terms and conditions, because anyone who has a credit card knows that you get from time to time updated or changed terms and conditions. You want to make sure that the terms and conditions that you have are actually the ones that were in effect at the time of the charge off or default. But more importantly, I've seen where it's the consumer or the consumer's attorney that files a motion for arbitration based on the terms and conditions, to many times to slow down the process or to muddy the waters in some ways. And again, you need to know what exactly those terms and conditions say, because many of them say the person electing arbitration has to pay for the arbitration. So while a motion in court could be filed to stay the proceedings and ask for arbitration, and then you could just sit there and wait because no one is taking the next step, and you're going to have to either go back to court or take some other action to indicate that it's the party requesting it that has to pay for it, and they haven't taken those actions. So again, you need to be familiar with these kinds of situations because they do happen, and you want to be prepared when you're in court, when a judge starts asking you questions such as, does it have this clause? Where is that clause? What are the obligations of the parties who are electing arbitration? You want to be able to talk intelligently about your file, because if you don't know that basic information, you really are sending a strong signal to the court that you haven't reviewed the file properly. And we all know that you're going to see the same judge repeatedly, and you're going to have more than one file with the same client. So these are the kinds of things that you want to be prepared about.
Yeah, we haven't talked about this, but Nathan, you just touched on probably the most important thing we can say today. And that is, it is crucial that you know your file that you have answers to questions when you go to court. The more you know, the more questions you can answer at the drop of a hat, when the judge asks, the better you'll look, the more they'll think of you. The next time you go into court, they'll show you respect. They'll believe what you say. When I used to go to court, I would take the account notes from law firm account notes, which had all the information. And the judge would say, well, do you know, did they get a letter? I say, wait a minute, Judge. Oh, yeah, on January 1st, a letter was sent to this address. Well, it got to a point where the judge would say, look, Mr. Williamson says that it must be there because he's got all the information. And I wouldn't have to even say anything. That's what you want to build up to. You want to build a reputation that when you come into that courtroom, you're ready to go. You're prepared. You know your file. You know what's in it. You know the information. You've reviewed it. You've got the documents which you need to go forward. Judges love that. And they'll make your life, they'll tell debtors, and they'll tell debtors' attorneys, hey, maybe you want to go outside and talk about it, because in all likelihood, they're gonna prevail if they go to trial. They usually come prepared. They've got what they need. They're going to prevail. So why don't you go outside? I suggest strongly you talk about settling it. Do you know how easy it is to settle a case when that's been done? Wow. You've got the judge on your side before you've done anything. And again, as Nathan points out, you're going to see the same judge. In most cases, in most states, specific judges handle these collection cases, the smaller ones, the under 20,000 cases. So you're there day after day, the same judge. You might have 10 cases, and they remember you. You made a good impression. It can't stress upon strongly enough how important making a good impression is, and that's how you make it. And going back to documents, sometimes it would be useful if you can get the note set from the original creditor. And what is there that's important? If there's been any disputes, if there's a notation when the terms and conditions went out, because talking about the terms and conditions, as Nathan pointed out, they change. Periodically, they send updated ones. And you need to know that. And I've had cases where, how do we know that this is the terms and conditions that were in effect at the time? And how do we know they got them? Well, obviously nobody knows that because it's all automatic within the creditor. But if you've got the notes, or you've got that will go a long way to closing that area of inquiry down. Okay, next slide. Exhibits. All right, well, we kind of talked about that. What's a contract on a credit card? Well, it's not the terms and conditions. Those are just the agreement. What are the terms? If you agree, how do you show that a contract, there's actually a contract between the parties? And that's use. And there's case law in many jurisdictions that when you accept the terms and conditions by use of the account. And here's another tip. Now, there's a case cited, but there's 2 cases cited here on the slide, but there should be cases in your various states for that proposition. I know that I was in New Jersey and New York. That's not the case that I cited in the 3rd Circuit. The 2nd Circuit. What you want to do, and this is a good example, is that there is a case that says when you use the credit card, the use of the credit card signals acceptance and creates the contract. Until you use it, there's no contract. As soon as there's no acceptance of the contract, there's an offer, but there hasn't been acceptance. Using it gives you, have that case in your hand. What I used to do is take that blurb from the case, that paragraph where it made that, it specifically stated that, put it on a piece of paper, have the case citation up top, and have the blurb below it. I would make it in 14 or 16 points so I could see it. When it was sitting on the table, I could just glance down and have that for that proposition. So if the judge questions, well, they question whether they ever got the account and whether there's any contract. You're suing them for breach of contract. Well, where's the contract? Judge, according to Roberts versus Bleed Bank, the court stated that when you use the account, it creates the contract. That too will impress the court, will show the judges that you're prepared, that you take this seriously. And it doesn't matter whether it's a $500 debt or a $50,000 debt, the same process, and you want to give it your same attention. And you create for any of the issues that we talk about, any of the legal questions that come up, you want to do that same thing. Have what I call a crib sheet of the various cases which you might need on your. They come, you need them all the time because it's all these cases they apply to. Have them ready. Have them with you in a little notebook or a little folder that you bring with you when you go to court, ready to go. The same way you want to bring some of the basics of evidence, the evidentiary rules. You want to get, how do you get in these documents if you're going to trial? How do you get the terms and conditions? How do you get in the statements in your particular jurisdiction? You want to do that research. You want to have it ready to go in your folder. So when it comes up, okay, so you got the charger statements, but how do you get into evidence? You're not the bank. Your client isn't the bank. Your client is a debt buyer. They didn't send it out. You need to check, do the research one day when you have some time. You do the research on these different questions and create a set of the case law ready to go and easily that you can really grab it and use it when you're on your feet, because that's important. We're not talking about submitting briefs. We're talking about on your feet, be able to spit it out. And if you have it at hand, you can do that if you're prepared. Okay, medical debt. Medical debt is particularly a little different. Clearly, do you have that intake form? And the intake form or forms will show that they've agreed to pay. They've agreed to pay if they're covered by insurance and the insurance only pays a part, that they've agreed to pay anything over that isn't covered by insurance. That if it goes into default, they agree to a collection fee. That's a real crucial issue, the collection fee. A lot of the doctors, they have a collection fee on their contract. It's not your fee. It's not the fee that your firm is charging. It's a collection fee that they add on at the time it goes into default before they send it out for collection, whether it be to a law firm or a collection agency. So many of them have, if we send it out for collection to any third party, we're going to automatically add a 15% collection fee. Then when you sue or you send out a letter, you send it out for the amount of, let's say the debt is $100, they have a 15% collection fee. You can send out a collection letter for $115. That's what they owe. And you have a contract that says that. Without a contract, you do that, you're gonna have a problem. But when you sue, now, if you're entitled to attorney's fees on top of it, and some contracts will say, they get a collection fee, the creditor, of that 15%. However, if they send it out and an attorney takes it to suit, they're entitled to reasonable attorney's fees on top of that. And that's going to be in the contract. And you need that contract in your hand before you do that, before you ask for that. So you've got to make sure you've got that. If there's any, you've got to be aware of the HIPAA rules in terms of the any statements which show medical services provided. It's tough if you've got no signed agreement, nothing. That's a problem. And quite frankly, it shouldn't be, because it's at this day and age, it's pretty rare. Unless a patient was brought in comatose to the emergency room, nobody sees anybody without getting them to sign on the dotted line. So next. Okay, personal loans and student loans. Student loans are an animal unto themselves, and there's particular documentation that's going to be involved with those, and you want to get that information before you send out. If you're dealing with student loans, then you want to read the Family Education Rights and Privacy Act and be familiar with that. Again, you want to see the written contract. If you're doing, say you're doing auto deficiencies. Auto deficiencies are when a car, a loan was taken out to buy a car, they stopped making payments, and the car was repossessed, and then it was sold. And for you to, and this is the difference between what you owe and what they recaptured at the sale. Was it, you need there's a list of documentation that you need to go forward on that kind of a claim. Again, in New Jersey, there's a statute that lists all the documents you need before you can pursue that claim. Other states may have something similar. You have to find that out. Is there a list? And you need to show that, for instance, in New Jersey, that the sale was commercially reasonable. Commercially reasonable might mean that there were multiple parties at the auction, the car auction, and it wasn't just sold under the table, it was sold to one particular individual for $1. You need to have the written contract that the debtor entered into when they bought the account, when they bought the car, and also you need the statement of account itemizing what the payments were and what's left. And that goes for any of these claims. You want to see the statement of account, what's been paid to date. I want to see a full accounting from day one of the debt. I want to see what's been paid on the account and when it went into default, and see what interest was added. And does it make sense? I also want to see how long it's been. You know, we talked about, this is something else that we haven't talked about, but how old is the debt? I don't know if anybody's familiar with the term debt parking. That's come up in recent weeks. The CFPB big time, and that's waiting on a debt, having a debt and just letting it sit. And maybe you've got a 6-year statute of limitations, and the debt went into default, and now you sit on it for 5 years, letting it accrue interest. That's a no-no, and not a lot of courts are aware of that. I don't think anybody's doing that anymore, at least not intentionally. Okay. Purchase debts. I think we talked about this, and to some extent, it's pretty much common sense. You want to tell the debtor why you're suing them, and give them a name. The more information you give them in the initial letter, the better off everybody is, because they know who it is, they understand, and they're more likely to contact you to settle it when they know exactly what it's about. I'll just touch briefly on the collection agency issue. You're representing if you're getting your cases through a collection agency, you've got to remember your client is not the collection agency. Your client is really the debtor. That's who you really represent. The agency is merely a servicer. And you need to know, and we talked about a little bit earlier, do you have contact with the client? Can you get a witness from the client? That's going to sometimes require that you talk to the actual client and not to the agency, and you've got to negotiate. You've got to speak to the agency, say, I need to talk to my client, because they're the ones that have to approve settlements. They're the ones that have to appear in court. Statute of limitations, that's different. They're different for the different types of debt. They're different they're all state specific, something you need to look at and make sure you review. I think this is self-evident, this slide. This is a major question, and you need to, in terms of when does the statute of limitations run from? Does it run from the date of last payment, last charge for goods and services, or the date when the last payment was due and wasn't made? I personally like to be most conservative, and I would say from the date that first payment was due, that's when it went into default. When that payment wasn't made, that seems to me like when it was, that's the default date, 30 days after the last payment. But that's something you want to check and see what your firm, how in your jurisdiction, how that how they decided to go. Okay, the idea that statute of limitations is affirmative defense, that's pretty much come and gone. Once upon a time, if it wasn't raised, you could ignore it. Not anymore. It's a straight up violation of the FDCPA to sue on a debt that's out of statute, and you just can't do it. And there's other various state laws, and there's right now they're talking in Congress. They want to pass a law that you can't even collect on out of stat debt. So, and this is crucial that you check the statute if it's close. Most law firms have this set up in their system to determine when to sue and when it's getting too close. And that's something you could, again, know about. What is your firm's position on that? Do they sue when there's 3 months left, when there's 6 months left? You know, each firm is different, but you want to check that out. Borrowing statute means that they may be using, because the jurisdiction is elsewhere, that's the statute of limitations that they use. And that's becoming more and more prevalent. At one point in time, the statute of limitations of the state where the suit was filed would govern. That's changed, and more and more it's going to the state in the terms and conditions. Meaning, if, like I said before, if you've got a Barclays account, they're using Delaware law and not New Jersey law or not New York law. New York has a straight up borrowing statute. New Jersey doesn't have one. It's clear cut, but it's most of the cases have applied that reasoning. They're just calling it, it's the contract, the choice of law provision in the contract. We talked about this. Then we just talked about this one. We talked about this problem earlier in terms of the jurisdiction, and it can be very tricky sometimes. Most times it's not, but there's that 1 to 2, 2% of cases where it is, and usually the local law firm will know where those hot spots are, and you can find that out if you're new, talking to somebody who's been there for a while. Okay, where jurisdictional limits. So this is kind of interesting. Why would you sue in one over another? So in small claims, there's a $3,000 limit. Special civil, there's a $15,000 limit, and in the law division, there's no limit. What is the other distinctions? Well, it costs more. There's a filing fee, which is different in all 3 levels. The cheapest is going to be small claims. So you'd say, well, why would I want to sue if the cheapest filing amount is in the small claims? Why would I want to file in special civil if the suit is going to be for under $3,000? Well, because in special civil, there's discovery. In the special civil, small claims, there's no discovery. In special civil, they have to file an answer, and if the debtor doesn't file an answer, you get a default. In small claims, you have to appear and wait and see as the debtor appear on the date of trial. There is no answer. And there's limitations on discovery in special civil. Now, law division, you could sue for $3,000 as well. The filing fee is going to be higher. However, there's no limit to discovery in law division. There's also no limit in terms of time frame. I said earlier that in special civil, they've got like a 90-day window for the most part, and they try to rush it through. In law division, there's not. Small claims might be even faster. So those are, and most states will have something similar, and those are determinations usually made by the law firm as what makes more sense. I know that I spoke to a law firm, they thought that was smart. We're going to do everything small claims because we're going to save all this filing fees. And then they discovered that they had to send an attorney every single day, whether an answer, because they didn't get answers. They had to go to see if a debtor would show up. Well, that they discovered was not cost effective. Special civil, if they don't file an answer, then you get a default. You don't need to go in New Jersey. The same as the law division. A lot of this is kind of common sense. And you want to think to yourself, Put yourself as a defendant. That's really what I think is the best thing you can do, is place yourself in the shoes of a defendant or a defense attorney and think, how am I going to defend against this case? That's going to give you an indication of what you need to do as the plaintiff's counsel, what you're going to need to prove. You're going to need to address all those defenses that you think of, and that's probably the best way to prepare. The other thing is the things that I talked about earlier, create a checklist for yourself. And eventually you'll do it, you won't have to look at it, but to check the file, does it have the terms and conditions? Does it have statements? Has a bankruptcy scrub done? Has a serviceman scrub? You check all these things when you look at the file before you do anything else, and see where it's at, to make sure that's meaningful attorney involvement. We haven't talked about meaningful attorney involvement, but that's being involved. That's being the lawyer. Know your file. Review your file. Review your file when it comes in. Review your file before you send out any letters. Review your file before you go to court. Review your file over and over again. Know that file by heart. These are not that complex. You want to know that file by heart when you walk into court. I've seen too many attorneys, when a judge asks them the question and they go, I don't know, I have to check with my office. Bad answer. You don't ever want to tell the judge, I don't know, about something that you really should know. Bad.
Yep, Mitch, I couldn't agree more. And again, these slides are available for those on the webinar to review. And of course, I'm sure Mitch would be happy to accept your email if there was any questions. And I think one of the benefits, especially being part of NCBA, is that you have colleagues. Everyone in the organization is happy to help another attorney, especially new attorneys. If you're a sole practitioner or you don't have the resources within your firm to guide you, I've yet to meet an NCBA member that isn't willing to discuss best practices with a new attorney. So remember that everyone is in this together and able to help each other. The biggest takeaway that I always have from these kinds of webinars is that if you want to be treated like a lawyer, you need to act like a lawyer. And that has always been an issue for industry, is that you can't take shortcuts. And I'm just so proud that our industry and our members don't. So with that, Mitch, I'm going to thank you for sharing your expertise with us today.
I would just like to point out one last slide.
Okay.
And that is this one. Before you file that lawsuit, remember, can you bring that up? The picture of the Simpsons, please? Because that just again, I'm beating a dead horse, but this is a horse that needs to be beat. Remember, when you sign a complaint, you sign a letter, you got to make sure that that's accurate. Because when you sign that, you're putting your reputation on the line. Okay, I can't warrant that. I can't say that strong enough. You're putting your reputation as an attorney on the line when you sign something. So you want to make sure that it's accurate, it's correct, and you can support what you've said. And with that, I wish everybody a good weekend. For those of you who are of the, I wish everybody a happy Passover and a happy Easter.
All right. Well, Mitch, thank you very much for sharing your expertise with us today. As everyone listening could tell, that you have a wealth of knowledge and there's so much to discuss, especially in these kinds of cases. While many people think these are simple, I think we've demonstrated that there's a lot that goes into preparation and learning the process. A recording of this webinar and a PDF of this presentation will be made available to those registered for this webinar and NCBA members. Please visit creditorsbar.org for additional resources and to register for upcoming events, especially for our spring 2021 conference that is coming up in Orlando, and for additional educational webinars and CLE programs. Finally, if you would please complete the brief survey following the webinar, which is a great place to include the CLE code that I read earlier. We count on your participation to guide our programming for the future. This concludes our event, and we thank you for your continued support for NCBA. Stay healthy, stay safe, happy Passover, and happy Easter holiday season. Thank you, everyone.
Thank you.